not certain what happened there, and why
Okay.
Mr. Richards came back in house. So.
All right, we'll figure it out.
All right.
Thank you.
Your Honor.
All right, we are here on the matter of the child, Abigail Dilara Geiger. This was a hearing that was held on February 10th and February the 15th of this year as to preliminary trial issues. The trial in this matter is actually set in May the 10th and May the 12th. And there were two main issues that were, I guess, on review on a motion. One was a motion to quash the subpoena as to the 8-year-old child from testifying on May the 2nd. And the other was a motion for a mother to have unsupervised visits. We have with us today Ms. Charlotte Mack, who's the guardian ad litem. We have Ms. Connie Regulate, who is the attorney for the mother. Ms. Lydia Hubble, who is also with us. We have Ms. Sarah Reese, who is the attorney for the father, Mr. Simone Gatter, who is also with us as well. I was going to announce an order, and I guess I got ahead of myself and actually decided to actually type the order. And so I think all of you all have received copies of the order, Ms. Mack, Ms. Regulate?
Well, I got Ms. Hubble's copy, I don't know if you have.
Okay.
Copy.
We'll get you, Ms. Reese, you got one as well? Okay. And bottom line, I think as all parties can read or see, that I have granted the motion to quash the subpoena for the child, so I am not going to allow the child to testify at the hearing in May, and then I am not going to change Ms. Hubble's visitation to be supervised, or to unsupervised, so her visits will remain supervised. The issue that I also addressed in there is Camelot has decided that they no longer are willing to do the supervision. I think I mentioned this at the end of the February the 15th hearing as well, that Ms. Hubble would need to find someone else to supervise the visits until we come back to May. What I have put in the order so that it doesn't necessarily have to come back. But if we find an agency such as Life Cares, which I know will do supervised visits, it can be through Life Care. Ms. Mack, I have asked that you, in the order, that whatever agency that Ms. Hubble can find, that make sure that it goes well, that you look out and see.
And Your Honor, so the court swear Life Care has indicated they will no longer do visits after they had to call the police at the last.
Oh, Life Care?
Well, Your Honor, we have a continuing problem, just like I brought to the court's attention before. Mr. Geiger insists in intervening in the visitation. I mean, it says even in the warrant that basically he's complaining that she's not following the court order. So I'm going to make an oral motion for a restraining order against Mr. Geiger that he stop interfering by contacting the supervision providers, because as long as he's contacting them, he's going to be giving them his own direction, which is not within Your Honor's order, and it's going to continue to be a problem. So,
Your Honor, he
I'm
was
not
not the
gonna bring that
problem.
up.
He was not even there when it
I'm
happened.
not. I'm going to deny that. The other thing that we are here for today as well, Ms. Hubble has filed, and I'm not sure if all the parties have received it, a new motion. It doesn't look like most people are served on it. A new motion.
No, I said no. I'm sorry. I was thinking no, but I'm orally saying no, I have not received a new motion, Your Honor. I checked my mailbox. That's where I was earlier. I was in the attorney room downstairs.
We'll get you a copy of it.
I don't know that I received one either. I got an email that she was wanting Charlena to file one, but I don't know that I got a copy of it.
and before we move from this order, I just want to make sure this would be a final order as to the denial of unsupervised visit because it arises out of the prior order. That's not a new action. So the denial of unsupervised visits is a final order for purposes of appeal under Rule 3. Is that correct?
Correct.
All right. Now, as to the subpoena, then, and not allowing the child to testify, I am going to make a motion for an interlocutory appeal on that issue because I think she is a material witness to this, especially given the court's position on the visits.
Ms. Race, any objection to the interlocutory appeal?
Well, Your Honor, just that we're already dealing with 3 appeals, and I'm sure this one's going to be appealed. I mean, as a matter of finances and him having to defend against all of these appeals, yes, I would object.
Well, that's not a defense, unfortunately.
Ms. Mack?
Your Honor, in regards to the interlocutory appeal, in regards to my client, if, at this point in time, whether or not the court allows Ms. Regulate on behalf of Ms. Hubble to pursue interlocutory appeal would not cause any harm to my client in any way. And again, I don't believe that it would be in her best interest to, I believe that it would be in her best interest to get a final opinion from the Court of Appeals. However, we are under severe time constraints already with preparing for a trial on May 10th. In that interlocutory appeal, as I understand it, it's going to be an expedited basis, so we should have a decision. Briefs have to be in, and we would have a decision within a faster time frame versus that, but that still leaves us in that time frame. We're in March with a final trial on this new petition in May. And again, I just believe it will cause undue duress to all of the parties to have to draft an appeal and await a response in lieu of moving forward with our trial. I guess my question for the court is, while waiting for that interlocutory appeal decision, would we be able to even move forward on May 10th?
You probably would. I'm sure there's enough testimony and other things that we can do until the appeal comes back. So I will grant the, I guess, request to have the interlocutory appeal instead of that decision. All right, have you all received the new motion as of today? As of yet? Mr. Holmes would make copies of it. This is a motion to grant mother sole custody and control of child pending further orders of the court.
Your Honor, I would also make an oral motion for an injunction prohibiting these continued motions. We have now had to deal with this same motion probably 10 times, asking for her to have sole custody while this is pending. And it's getting silly, it's expensive for him to have to litigate against. So I would ask for an injunction keeping mother from being able to continue to file these.
What I'm gonna do is I'm gonna allow her to file through her attorney only. So she has an attorney, and I'm not going to, and I think attorneys know the standard of proof and the things that ask that. For me, first and foremost, to do a change of custody from one side to the other to sole custody requires a petition to be filed, and I think an attorney would know that versus a pro se person. Since she has an attorney, any further filings need to be filed through her attorney.
Well, Your Honor, this is obviously filed as a pro se. I mean, I represent her on a limited function. It is juvenile court, and she has a constitutional right to access to the court,
She
so.
has an attorney, and she will file whatever between now and the May 10th. If she feels the need to file something else, that would need to go through her attorney. So that would be, so as to this motion.
As to the motion
Let
for
me let y'all-
injunction,
Let me let you all look at it for a moment.
well, as to the oral motion for injunction, because we now have had one oral motion for restraining order against Sinan
That's denied.
that is denied, and the oral motion against Ms. Hubble is in essence,
Granted, in part, she's to file any other new filings need to be filed through her attorney.
and Your Honor, in regards to that actual issue, I know the court has made a decision in regards to that, but we need some clarity. And I've heard Ms. Regulate say that there's a limited function that she's working as capacity of the attorney.
I'm not doing anything else. If there's anything else to be filed on
In
this
regards
case,
to this
it's to be
petition
filed-
number,
Is to be filed by the attorney only.
okay.
I don't think that needs any further clarification.
Well, the one reason that, Your Honor, is because Ms. Hubble's motion has a different petition number on it, and that's why I was trying to get clarification, because her motion has a petition number 223-886.
I don't know what else,
Well,
there's
it's
a
right
bunch of
here,
stuff
so
to
it's
do.
one of
So
these. I don't know what that is.
Right.
I don't know what they are. There's a bunch of motions, petitions, nothing else to be filed pro se. All further proceedings should be filed through the attorney only.
Okay, and again, just a little bit more clarification for Ms. Hubble, not only in filings, because I don't want to risk, I'm guardian ad litem for the children, and Ms. Hubble sends me group texts and group things, and I've discussed with Ms. Regulate in regards to that. I don't respond to those things, and I just would like some guidance from the court as to helping Ms. Hubble understand that all communications with me, because I don't want to overstep my bounds. I've never responded to any of her emails because she's been represented by counsel or her text, but I just wanted to make sure that Ms. Hubble understands that all those email communications and texts to the guardian ad litem, I would prefer that she filter those through her attorney before she sends them to me personally, Your Honor. Sorry. Just protect her and protect me, Your Honor. Because as you heard Ms. Regulate say, there was a limited purpose before, and I think Ms. Hubble was understanding that was a limited purpose before. And to be clear, on this case, Ms. Regulate is the attorney of record for all matters in and out of court going forward.
Well, I mean, if she doesn't want a text from Ms. Hubble, all she has to do is block her phone number. I mean, that is, I don't know of any law that says a parent cannot contact a guardian ad litem. I just don't think that exists, so all she has to do is block her number.
I'm not asking that there be a law. I'm genuinely asking so it's made clear to Ms. Hubble as well as to Ms. Regulate that we're all on one accord, that to protect Ms. Hubble and to protect all the parties with communication, that it be filtered through her attorney before it's sent.
And I would join that motion, Your Honor. I've been getting emails from Ms. Hubble as well, and we can't respond to them because she has an attorney.
All they have to do is block her number, you know, she's certainly got a right to contact the guardian ad
She
litem
does.
if she has a concern about a child. On
Why
this
is she
reason.
not contacting through the attorney? That just doesn't make sense. If she has an attorney, why is she not telling her attorney the concerns?
I don't
letting
know,
her
and
attorney to-
I don't know which particular one or text she's talking about, but,
I'm not
I
gonna,
mean,
let me just say, I understand your concerns, Ms. Mack and Ms. Reese, and it does not make sense to me as well that a person who has an attorney is not utilizing the services of an attorney and is probably filling your emails with things that you cannot respond to because she has an attorney. I don't know if my arms reach that far and to tell her not to do so, but I will say that she's not to file any other motions or any petitions without her attorney, at least until the May 10th proceedings are over, and then we'll address it after that. So, I'm done, in the interlocutory appeal, we'll go forward. We'll see if we have the results of the interlocutory appeal before then.
and I will submit an order on that. Okay, so we'll actually have an order that it's Rule 3 for the purposes of the unsupervised visits and interlocutory is granted as to the testimony.
Okay, all right. Make sure you submit it to both parties.
Are you
first.
doing an order on everything or just those two?
I'm just doing the order on that. This order is the final order as to the supervised visit because it arises out of the prior order. And so it's directly appealable under Rule 3, and then that the denial of the child's testimony was an oral motion for an interlocutory was granted. So that's what I'm doing, just to this order, because everything else is separate.
So if you want to do the other part of us to deny the order against Mr. Dilara and specifying that the mother shall not file anything else without the assistance of her attorney.
In Ms. Reese's order, just for clarification for the purposes of appeal, it would just be so much more flowing if there was one order, if we stated that we had the oral motion for Rule 3 by Ms. Regulate, that was granted. The oral motion for the restraining order by Ms. Reese, I don't know your married name, was
all right.
I'm not even used to it anyway, so it's fine.
Okay.
All right, Ms. Reese was denied, and then the third motion oral motion for injunction was granted in part and denied in part, and that Ms. Hubble needs to file all pleadings going forward pending final hearing on this matter through her attorney. at that point, because I think we had 3 oral motions, Your Honor, before this court today. And then we also have the mother's motion, pro se motion, and a ruling in regards to that, Your Honor.
And I just think the appellate issues are really kind of separate. That's the order that needs to go up to the Court of Appeals, so.
Well, I'm not disagreeing with the separate motion for that issue. I'm just saying, for the purposes of this hearing, we heard 3 oral motions and we have 1 written motion at the court. So it's actually 4 motions that we're hearing today on top of the ruling.
Yeah, and she's gonna write order on 2, and she's gonna write order on 2. Okay, that'll be the court's order.
And
I'll see y'all
this
Monday.
motion is denied, Your Honor?
Oh, I forgot about this motion. I'll just roll that motion on over to the final hearing.
Ms. Hubbell's motion to the final hearing.
Are you gonna put that in your order, Ms. Rice?
Yes.
Even though, Your Honor, you said that custody matters should be filed.
I'm just gonna roll it.
So that means that on that day, we're gonna have to have a hearing in regards to this motion.
Really? It's probably the same exact proof that you was gonna present anyway, so.
Can we have another print of this order so I can have one? I can have one? Thank you.
It's maybe I thought I was gonna get to you before 10:30, but it looks like I'm getting to you right at 10:29.
Thank you, Your Honor.
All right, thank you all. We'll see y'all in May. And by the way, I apologize, there's also a motion for relief, I did not see that.
Yes,
For
that
the
was-
Department of Children's Services,
That's
I'm
the fifth.
granting that I think that was, alluded to in the order, that Ms. Supple would be responsible to find some.
Your Honor, in your order, you said that I had to approve of whatever agency or supervisor. Is the court's instructions that it has to be an agency, or could we find a